In this video, I want to talk about my perspective of the logistics of when there are two or more co-trustees serving to administer your trust. Now, a lot of times I have clients and they cannot pick between their two kids. I can't pick between my daughter and my son. I need to have them both together. Someone's feelings will get hurt. I want to have both of them as co-trustees. And what I tell clients is that, hey, you are the best judge of your kids. You know them much better than I do. So if you want to have co-trustees, let's just talk about what some of the pluses and minuses are. And there are other videos that are being done on this subject because it's beyond the scope of this. But in this particular video, I want to talk to you about the logistics of actually working together as co-trustees. And the whole idea of estate planning is to make life easier on whoever has to pick up the baton and carry it. But one of the challenges is that if you have co-trustees, the trust needs to be very specific about what is required of those two co-trustees when they actually go do something. So, for example, if the trust says nothing at all, it just says, I nominate Joe and Jane as co-trustees, and that's it, then the banks are likely to require both Joe and Jane's signatures on every check. If you call and talk to a broker and want to execute a trade, they're going to want to speak to both Joe and Jane. Well, what if Joe lives in Colorado? What if Joe is on vacation? What if he's difficult to reach? It could make it really very logistically challenging to have both signatures required on every little thing that they do. So my suggestion is to pull that estate plan, off the shelf, get it from the bookshelf, dust it off, take a look at it. When you nominate your two kids, for example, does it say anything about the signature requirements? If it doesn't, then there could be a logistical challenge. One suggestion, and it should not be used in every case, but one suggestion would be for the documents to say, hey, Joe and Jane have to agree, but once they agree, only one signature is required to actually execute on the action. This will make it a lot easier for them to coordinate and actually take the event. I have so many clients that say, oh, it's all laid out for them. It's all in black and white. All they have to do is follow my instructions. But you need to think about the fact that Joe and Jane, or your kids, could be handling your affairs for years. If you have Parkinson's or dementia or something that afflicts you for a long period of time, it is a marathon. It's not a sprint. We want to make it as easy as possible for them to get along and for them to actually execute on behalf of you as the trustees of your trust. Thank you very much for watching. I hope you found this information helpful.